Hello, good morning. I'm sorry for the registration issues. I couldn't registrate, I couldn't record the first part of my lesson about the concept of state, where I made some preliminary considerations about the notion of state, explained the state as a source of law, parallel to Hans Kelsen definition of the state. The state is sovereign, so it's the creator of law, and the difference between international organization and a state as actors of international law is that state has sovereignty. International organization is only regulated by the principle of conferral of competencies. For example, Article 5 of the European Union Treaty explains, second paragraph explains that the European Union has only competencies, attributions, so the European Union has no sovereignty. And I explained in those preliminary considerations what means the difference between actors and actors of international law, which are legal subjects of international law, which are legal persons of international law, which can create international law, and in the other hand, individuals, firms, associations, private initiatives, which are not subject of international law, which are not legal persons of international law capable to create international norms. Persons cannot make treaties, persons cannot create international principles. After those preliminary conditions, I analyzed the the fundamental conditions, three fundamental conditions, two of three fundamental conditions of the concept of state: territory and population. The territory is analyzed as lands, seas, and airspace of the state, and we saw that there is no strict definition in international legal order of the concept of territory. So the international legal order has very wide acceptation of the concept of lands, seas, and airspace of the territory. For example, there is no spatial volume quantity constraints in international law. The state can be very little state. There is no legal statutes of the territory. This territory can be disputed by other states. In the case of Armenia and Azerbaijan, there is no difficulty about the definition of states, but there is a territory disputed. But the fact that there is a disputed territory, it doesn't implies the disqualification of the legal concept of state. And I also explained that there is no obligation to have contiguous territory in state. For example, in France, we have overseas territories which are dispatched in globe, in the world. So the France is has a dispatched territory. So those situations are admitted by international legal order. The second condition, population, I explained the difference between the concepts of population, people, nationality, and citizenship. Always those legal concepts have different meanings. For example, nationality, it's a legal statutes decided by a sovereign state. But the citizenship, it's more precise legal statutes which allows to the person political right, to have political rights for participating to elections, etc. And I also made the difference between for example, Russian or American conception of citizenship. There can be a multiplicity of citizenship. Russia and United States are federal states, so there are plurality of citizenship. There is federal citizenship and national citizenship in those federal states. Also, in Great Britain, there are different kind of citizenship with different legal rights according to those statutes. For example, British Gibraltar territory inhabitants population has no equal rights, political rights, to British Great Britain inhabitants, citizenship, citizens of Great Britain. But I'd ended this lesson by telling that there can be interferences between national and international citizenships. For example, in European Union, there is a European Union citizenship, which is not a national legal statutes, but which is a statute linked to the European, to the nationality of a member state. So there can be some interferences between those concepts. But according to my first lesson, I would like to repeat that there is no international legal rule limiting, precising deeply what we have to understand about the concept of population or concept of territory. I gave the example of the case, Nottebohm case of 1955 before the International Court of Justice, where the International Court of Justice admitted that the effective nationality can be required by a third state in order to consider the nationality given by another state. So fundamentally, there is no legal strict definition of those concepts in international law. Sovereign states decide freely about those concepts.